Not yet?
Okay, now try.
Okay, I will try it. Now, fine? Okay, I was thanking the directors for giving me the opportunity to be here with also these worldwide famous professors, also with my colleagues from here, from Spain, from all around Spain. And I will not take more in time. I just want to introduce Professor Edwin Smith and Professor Steve Weise. They come, Professor Steve Weise come also from he's now the co-chair of the American Law Institute, European Law Institute project for economic data. He is also a member of the American Law Institute, also from the American Bar Association, and he has been one of the members of the draft committee for the Article 9 of the UCC. Also, Professor Edwin Smith is a world-famous attorney at New York and Boston at Morgan Lewis. He is an expert in bankruptcy law, debt law, finance law, and domestic in the United States, and also international affairs. He is also not just attorney or professor, also advisors for several international institutions. And well, we are flattered, we are very pleased that they could come here today to talk about the Pdapl principles and also the UCC. And I will steal more time. I just give them the floor. Please, go ahead.
All right, thank you very much. And Ed and I are both pleased to be here and to have an opportunity to talk about the principles and how they relate to the Uniform Commercial Code and some of the underlying reasons for the principles. Let me note for a start, Ed and I are going to break two rules for making presentations. Instead of a PowerPoint, we're going to have, let me see if I can get it up there. Maybe the people will get it up for me. There it is, good. We have a chart, a comparative chart. We're thinking of comparative law for this purpose instead of a series of slides. And our second rule we're going to break is that instead of sequential presentations, we're going to go back and forth and talk about these things in more of a discussion roundtable format. So we hope that's allowed, David, but we will plow our way through all of this. So what Ed and I will do is go through some of the basic or the core items as Hideki referred to earlier, talk about, to some extent, you've heard about some of it yesterday, you heard some of it just now from Nacho and Hideki, a little bit deeper into some of the principles and explain what was going on. We'll attempt to address some of the concerns that were raised yesterday and how the principles deal with them. We'll talk about all of this in the context of the goals of the principles to have certainty in transactions, to have uniformity across borders, because digital assets, of course, have no location, so that one engaged in transactions involving digital assets doesn't matter whether I'm sitting here in Spain or in California or state of Washington or someplace in Asia, whatever it might be. So it's best, if possible, to have as much uniformity of approach and results and consequences as is possible. As we go through all of this, I'll identify the principle, sometimes say a lot, sometimes say just a little about the particular principle, and again, related to some of the concerns that were raised yesterday, related a little bit to United States law outside of the Uniform Commercial Code, our common law, and we recognize, of course, that that's different in civil law countries. And then Ed will, for each issue, talk about how the Uniform Commercial Code addresses that issue. And as I think you'll see, in most instances, we have a lot of uniformity or consistency between the UCC and the principles, and we think that's a very important aspect of this. We think the net result is that we'll have, through the principles, the substance of the principles, more consistency and predictability in the markets that are trading in these kinds of assets. and hope that will enhance the transactions, make them less expensive, and make them better for everybody. Now, Ed, any introductory comments?
Yeah, we are very grateful to David and Carmen for inviting us. We are quite honored to be here. We also appreciate that you are letting us provide this presentation in English. I'm reminded that a year ago, my wife and I were in Chile, and we went to a very nice restaurant, and the maitre d' met us and said, "My English is very bad. My wines are very good." Our Spanish is very bad. The principles are very good. So we look forward very much to sharing our thoughts with you and getting your thoughts. Thank you.
Okay, thank you. So we will start with the first page, which is a good place to start, in our comparative chart. And in the scope, and there's been some discussion yesterday and a little bit today about the scope, and we've talked about digital assets, and they have to be controllable or controllability, as Hideki said earlier today. I just want to emphasize that that the entire set of principles flows from the definition of digital assets at the very beginning and the scope provisions, so that any digital asset that does not fit the definition of digital asset as used in the principles is simply outside the role of the principles, and we don't have to be concerned that the various principles somehow affect directly other kinds of digital or electronic assets that don't come within the definition. And as has been discussed, the most important part is the question of controllability as a necessary and critical component of the definition. In the United States common law, before all of this, there's just general rules of property law that apply to this. We'll come down to that a bit more in a moment. So Ed, how does the Uniform Commercial Code address this?
Well, mercifully, it is very close to what the principles do. I think you heard from Ignacio that the two projects worked in parallel, and we communicated with each other quite a lot and learned quite a lot from each other. We started off in our draft of the Uniform Commercial Code changes referring to a digital asset, and everyone was confused by that because the term has so many meanings to so many different people. Some people would say, well, when I send you an email, is that a digital asset? So what we wanted to do was to capture those digital assets to which the marketplace attributes a value, and not to other digital assets. And we also wanted to be, like the principles, technologically neutral. So we came up with this term, controllable electronic record, a record which can be a writing or in electronic form, but which is in electronic form, and which is subject to control. And when we talk about control, we'll go into more details, but the easiest way to think about control is trying to repeat the attributes that one would normally see if you were possessing a physical object. So we were trying to do that for an intangible object, and the principles, of course, took the same approach.
Thank you, Ed. The next item in our comparison is the question of proprietary or property rights, and has been indicated the principles have an express statement that digital assets as defined in the principles can be the subject of proprietary rights. In the United States, our law of property is all common law. It's not set forth in statutes. But as one case which is cited in our chart notes, that intangible things can certainly be property for these purposes. And there's little question about that. There is some debate in the United States about whether one can injure an intangible thing and have a tort claim for injury to it, but that's a separate question. So the use or the thought in the principles that digital assets can be property is not unusual or inconsistent with U.S. common law. Ed, how about the Uniform Commercial Code?
Well, I don't know that any of us ever question whether a digital asset can be property. We are probably lucky in that respect. We did not have the case law that existed in the United Kingdom, which required a new legislation. As I understand the United Kingdom law, the English law, is that you can have a tangible object and you can have what they call a shows in action. But there was no place for a digital asset. So there had to be new legislation to recognize a digital asset as what was referred to as a new item of property. In the United States, we did not have that issue. We accepted as a premise that any sort of right in any tangible or intangible was property.
So again, consistency here through different approaches, but we end up at the exact same place, I think, under United States common law, United States UCC, and the principles itself. Ed, there was a discussion this morning a little bit about tokenization of securities and whether the principles apply or don't apply or how they might apply in the U.S. common law. There's really nothing that addresses that concept. How about the UCC?
Well, this goes to the whole question of linked assets, which we're going to come back to. Because when one thinks about what a token is, the token is just the electronic record. It's just the data. And for that data, in the context of securities, to give the person who has the token the right to exercise the attributes of the securities, you need to somehow link the securities to the token itself. And so, Steve, we haven't really taken that step in the US to provide that link, but that takes us to the whole subject of linked assets.
And the principles, of course, address the question of linked assets, and as a general matter, take the approach that the effect on they call it the target asset, of a transfer or a security right in the primary asset, let's call it, is not addressed by the principles, and instead is addressed by other law. And if other law says or provides that some effect, particularly a proprietary effect on the basic asset, has a comparable effect on the target or linked asset, fine. Then the rules that apply under the principles to digital assets can have an effect on the linked or the target asset. And if other law doesn't provide for that, then go look to other law for the effect on the linked asset of a transaction, whether it's a transfer, a security right, qualifying purchaser, or innocent acquirer, all these rules we'll talk about in a couple of moments. Then the principles can progress to apply. Again, in the common law of the United States, it's all not clear at all. There are all sorts of people out there who claim that if I take a token, I can get the real property across the street. doesn't work, but people are selling it out there, and it's scary as to what's going on. So Ed, I think the UCC did a narrow approach to this.
Well, we did, and I should emphasize that the concept of a linked asset is not unusual. It's something we're all familiar with. For example, a paper promissory note embodies a right to payment. Well, the promissory note is just a piece of paper, but we give that piece of paper meaning by saying, with that piece of paper, you obtain that right to payment. Same with documents of title. I may have a document of title which gives me rights in the underlying goods, but the document of title itself is just a piece of paper. So we already, in our legal systems, have linked assets. We just weren't referring to them as linked assets. When we came up with our definition in the UCC of controllable electronic records, we didn't want to interfere with those systems that already exist. So we exclude from the definition of controllable electronic record electronic documents of title, what we call transferable records under our Uniform Electronic Transactions Act, dematerialized securities for which we already have rules. And then that left us with the pure definition of controllable electronic record. But when you have control of a controllable electronic record, normally you just have the control of the data on that record. Now, that works fine for Bitcoin and other cryptocurrency. But how does that record then link to other assets? And what we did was very similar to what the principals did. We said that area is too vast. We can't possibly create legal rules for real estate, for non-fungible tokens, for intellectual property, for securities that link those assets to the controllable electronic record. But there was one area where there was great demand that we establish a link. And that was where the controllable electronic record evidenced payment rights. Because under our Article 3 of the Uniform Commercial Code, if you were to try to obtain a negotiable promissory note, that would have to be in writing. It would have to be a paper note. And with a small exception under our Uniform Electronic Transactions Act, to have an electronic right to payment that has the attributes of a promissory note, you have no specific statutory law. You just have a contract that's created electronically. And there was a demand in trade finance for there to be electronic promissory notes. This was especially the case during the COVID pandemic, where there is desire to trade with electronic promissory notes and electronic bills of exchange, and no real law in the United States to create the same attributes that you would obtain if those instruments were in written form instead of electronic form. So we said that if you have a right to payment that arises from providing goods or services or a loan, that if the controllable electronic record evidences that right to payment, then the transfer of the controllable electronic record carries with it those rights to payment as a matter of statute. And we'll get into more detail as to what that means, but think about the fact that a controllable electronic record that evidences this right to payment can result in an electronic promissory note or an electronic bill of exchange that is recognized under these amendments.
Thank you, Ed. So our old friend, private international law, which, as you've indicated this morning, which you've heard this morning, rather often brings some controversy with it. And you've heard about the waterfall. I'm always thinking about wearing a raincoat when I talk about this, that occurs and how it plays out. And there's been, the goal here, coming back to the initial comments I made about the policy goals, the goal here is to have predictability. And as I'll note in a moment, under the U.S. common law, there was no predictability on third-party rights as against these kinds of assets or proprietary rights that might exist. So in designing a private international law rule in the principles, instead of using the traditional connecting factors that people are used to, the goal was to come up with a very clear, or as clear as possible anyway, set of factors so that persons engaging in these transactions would have some reasonable chance of predicting which state's law would apply, and therefore predicting what the results would be of the transaction, whether it's an outright transfer, a security right, whatever the kind of transaction that might be involved. U.S. common law in this area is similar to the traditional connecting factors rule, and there's little predictability, 4, 5, 6 factors. They have different weight depending on the transaction. You just don't know where you're going to end up in a transaction, so that it is important, I think, to have as much precision and predictability as possible in these rules and not have to go to a balancing test or a many factors test each time in order to try to figure out where you're going to end up, because that reduces efficiency, increases uncertainty, and all those bad things that we're trying to avoid. So Ed, how did the UCC deal with this?
Well, once again, we will find a lot of symmetry with the principles. We start off with a very similar waterfall, that you look to the law that is stated in the controllable electronic record as the, quote, location, unquote, of the controllable electronic record, and then you apply that law. If the controllable electronic record itself doesn't provide for that law, then you look to the system in which the controllable electronic record is recorded. And if that system provides for a governing law or the location of the controllable electronic record, you look to that law. Now, as Nacho pointed out earlier, if you look to Bitcoin, there's no governing law. There's no system that provides for governing law, so we had to have a residual rule. Now, we don't have the residual rule that you find in the principles, where you look to the location of the issuer. It's probably the case that most of these controllable electronic records don't have an issuer, or if they do, they relate to securities, which we handle in other law. But then the idea was to try to have a residual rule, one that points to the substantive rules of our Uniform Commercial Code changes. So how did we do that? We said, well, you look to the law of Washington, D.C. If Washington, D.C. has enacted the amendments, then you look to Washington, D.C. law. If it hasn't adopted those amendments, then you just apply the substantive law of the amendments. Now, Washington, D.C., we are glad, did enact the amendments, so you don't need to think about applying the substantive law. But the most important point here is one that I think Steve mentioned earlier, and our last panelist mentioned earlier, and that is the more that the substantive law of each country is uniform, we don't need to worry as much about the private international law rules because they get you to the same result no matter which jurisdiction's law is applicable. And so through this process, we tried to work very carefully with Unidroit, with the United Kingdom Law Commission, and with other law reform organizations, with the hope that our applicable private international law rules will be as uniform as possible, but even more importantly, that our substantive law rules will be as uniform as possible.
Yeah, and let me note that the scope of our choice of law, private international law rules, applies in 3 areas, 2 areas, 2 or 3, it depends how you count. Anything covered by our Article 12, which we'll talk about a little bit more, which are the rules for innocent acquirers, we call them qualifying purchasers, we'll talk about that more in a few minutes, our shelter principle, and when we talk about secure transactions later, which of our states, and of course in our language, state is a subpart of a country, and in the international language, state is
A unit.
a unit of the United States, right? So that also goes to the predictability, because we wanted the exact same law to apply for a non-secured transaction and for a secured transaction, because somebody involved in one or both of those transactions or either transaction should get the same result. The same set of rules should apply. And again, all of that comes back to predictability. And the other thing to note here is that while it's fun, and we always talk about Bitcoin and crypto, as Ed mentioned, particularly for the linked assets, that our definition of controllable electronic record, similar to digital assets as defined in the principles, is much broader than crypto. And although one often thinks about this in terms of examples of crypto or Bitcoin, the controllable accounts, the controllable electronic records more broadly, the controllable payment intangibles, all these electronic rights to payment are readily inside of these new rules that we have. And I think Ed and I think that while in the press one might see discussion of crypto, in the business world one is more likely to see transactions involving payment rights, which get the benefits of these rules similar to the rights one would get for paper negotiable instruments, for example. So let me go on to the question of transfer, which leads into questions of control. And of course, as you've heard, the principles generally look to the question to other law as to how to accomplish a transfer. And the principles, I think Nacho used the word, if I got the right translation, are modest in what they attempt to do. They don't try to answer every question. Other law has sufficient rules for how one accomplishes or agrees to accomplish a transfer of a transaction. And importantly, as was noted before, and we'll come to this a little bit later, transfer includes any kind of movement, I'll avoid the word transfer, of a proprietary right of either full ownership or something less, such as a security right in a digital asset, in order to, again, consolidate the rules so that a single body of rules applies to a set of related transactions, and in the United States in particular, under our common laws, it wasn't always clear whether a transaction creates a security right or does not create a security right as an outright transfer. We call this a true sale question. And rather than having to solve that question every time, as you'll hear from Ed in a few moments, the same rules under our secure transactions law apply to sales of payment rights or to a security right in a payment right to secure an obligation of some sort or other. So why don't I stop here with transfer before we go into control, and Ed, how does the UCC deal with transfer?
Well, it's a very broad term, and of course, we have the same issue of when one refers to transfer, whether you're talking about a transfer of full ownership or transfer of a security right. We had in our Uniform Commercial Code a phrase, assignment, and some courts interpreted assignment to be a full transfer of ownership, and others interpret it to be a grant of a security right. So we had different lines of decision interpreting the same statute, and we had to provide in this change, the Uniform Commercial Code amendments, a statement that made it absolutely clear that when we use the term transfer or assignment, that we are referring to either a transfer of outright ownership or the creation of a security right. It could be either.
So again, a pretty broad notion there, and some clarity in how the various rules apply. Let me make a brief comment on the word resulting, which has had some discussion already yesterday and today. In large part, what that addresses is the possible circumstance where if I want to transfer a digital asset to Ed, what Ed receives is not exactly what I sent, because the system on which the digital asset is created or maintained may cancel my digital asset, and a new one emerges and is in Ed's wallet, no longer in my wallet. So without having to get metaphysical about all of this as to whether it was the same or whether it could be traced or not, the principles just take a very direct view that if there is a resulting asset, that you sort of know it when you see it, that the same set of rules are going to apply without having to spend a lot of time worrying about how all this fits together or doesn't fit together. Ed, something similar like that?
Yes, the result of a resulting asset is the same under the Uniform Commercial Code.
And in U.S. common law, we would have had a lengthy analysis and debate over whether it can be traced or not under what we call equitable principles. And let me note, drop back, you'll see in our chart under the United States common law many references to what we call restatements. And you heard earlier references to the American Law Institute. Ed and I are each members. I'm on its governing board. And the American Law Institute, unlike Unidroit, has been around only for 100 years, not 104 years, like Unidroit. And it was founded by former President of the United States, Taft, and other prominent lawyers and judges at the time. And one of the principal, no pun, one of the principal effects, projects rather, of the American Law Institute, similar to the European Law Institute, is to prepare what's called a restatement. Our units of the United States, our small s states, have common law courts that develop their own rules for contracts or torts or property law, and it's difficult for sometimes transactions that go across state or unit, I'll call them unit borders, unlike the UCC, which is adopted in every single unit, so it's easy to have cross-state, cross-unit predictability. What the ALI started doing 100 years ago is to compile all of the cases in all of the states, look for common rules, common threads, and then restate them again in a synthesized manner so that both to promote better law, because maybe this state had a good analysis of that issue and this state didn't do so well, to help the judges and the lawyers doing transactions to come up with approaches to these transactions. And many states give a high level of deference to these. There's no official status except doing a good job. And the ALI restatements in property, contracts, torts, a new one on consumer contracts, all these kinds of areas receive great deference from the courts and are cited thousands of times, I'm not exaggerating, thousands of times in court decisions. So that's why we refer to some of these in our chart in the column for the United States common law to try to develop unified approaches through the common law in the United States, and happily that works pretty well. So let me move on to the question of control. Of course, that's received a lot of attention in these transactions. And you heard in the principles about the various exclusive rights and how that works. And there was one concern yesterday about, well, how do you prove you have this exclusive right or that exclusive right when there could be anybody out there in the universe that might have one of these rights or not. So Principle 7 anticipates that problem and addresses it. And it says that if a person can demonstrate that person's identification as is required in Principle 6 for purposes of control, then that person is presumed to have the other components of necessary for control, the various exclusive rights to use, exclusive rights to keep others out, exclusive rights to make transfers. So in effect, in procedural language, at least we think of it as procedural language, that shifts the burden to the person challenging control to show that somebody else, maybe that person, the other person, actually has the control there. So one does not have to prove the negative, so to speak, which would be an impossible task, given that anybody out there might have some sort of claim or ability. So this presumption serves an extremely important function in this process and should make this all feasible.
But it's not just the identity, though. It's the person identifies himself as having these powers, but also makes a case that the person does have those exclusive powers, and that it's up to someone else to rebut that.
Right. And the UCC has a similar rule?
It does. It's almost identical.
Okay, good. So again, uniformity, consistency, efficiency in the markets. Another aspect of understanding the markets, as we were preparing the Uniform Commercial Code provisions, we knew that we didn't know everything about crypto or Bitcoin or technology or electronics. So we were modest again in that way, and we invited into the process business people and lawyers who knew nothing about commercial law, but knew everything about crypto or digital assets. And we said, here's what we would like to do as a matter of commercial law. Does that make any sense as a matter of electronic transactions and things like that? And most of the time they said, fine. Some of the time they said, you're crazy and you need to deal with this. And one of the things that came up are the sharing of control. And they said it was a common transaction to have what's often referred to as multi-sig or multi-signature requirements, and the principles address this directly in Principle 6.3b, that the fact that I have the abilities we just referred to in the definition of control, but that somebody else also may have those abilities, doesn't detract from my status of having control, as long as I still have some control, as long as I haven't given it all up, and the fact that there may be two of us that have control is okay in these transactions. As a matter of U.S. common law, we have concepts in property law of joint tenants and tenants in common, but those didn't deal well with this at all. So how did the UCC fill this gap, Ed?
Well, we did something very similar for multi-sig, as it's called. I will say a lot of the experts in this technology showed up, and a number of them were cryptocurrency experts, and they thought we were going to deal with such issues as regulation, taxation, or anti-money laundering. And we had to explain, no, we're just plain commercial lawyers. And so they went away. But then we had the real experts who were interested in the commercial law. So the multi-signature sharing concept that Steve mentioned is also in our Uniform Commercial Code amendments. And just to add a little more detail, if Steve has the power to transfer the asset and the other powers, and I have them, and either one of us can exercise those powers without the consent or involvement of the other, then each of us has control. But if I can exercise those powers, but Steve cannot without my consent or involvement, then only I have control, and Steve does not. And there are other ways even to structure control. For example, David could have control, and he could agree with that if either Steve or I tell him to transfer the asset, then Steve or I have control through David. And similarly, if I can give David instructions, but Steve has to consent to those instructions, I do not have control. So those, and we find some of these control mechanisms to be very prevalent in the marketplace, and so we were trying to adapt or recognize what was going on in the marketplace. We were told unless we had multi-signature provisions, that the marketplace would not support what we were doing. So we had to create those counterintuitive provisions which say, yes, you have exclusive control, but no, we don't really mean it when we're talking about multi-signature.
And similar to the principles, the UCC has many examples in its comments. And when Ed and I give lectures on this in the United States, we tell people, before you read the statute, read the comments, because they will tell you how to read the statute. And the statute itself is perfect in the sense that if you read the words, they say what the comments tell you they mean, but it's very hard on a first or second or third or fifth reading to get there without the help of the comments.
I have been known to say that you should read the comments, and only if you see an ambiguity should you read the statute.
So let us go on to the sort of the core substantive provisions, putting aside secure transactions, and that is the question of what sometimes, of course, referred to as the shelter rule, and in the principles, the innocent acquirer rule, and it'll explain in a minute or two, the comparable kinds of provisions in the Uniform Commercial Code.
Now, this is the important part, because often people get caught up in trying to figure out whether there is an electronic record, whether it is subject to control, whether you've met all of the requirements for obtaining control, and then forget that the whole reason for having control of a controllable electronic record is to be able to apply the substantive law rules relating to a transfer of a controllable electronic record. So now we're going into why we have these definitions and what their impact is.
So the principles start with sort of the unstated or underlying concept of Nemo dot. You can't transfer more than you have, except when you can. And we'll walk our way through this. But part of Nemo dot in the principles is the shelter rule, is that what you do have, you can transfer onto somebody else, even if that somebody else, had they been a direct transferee of your transferor, might have been subject to other claims, proprietary claims of one form or another to the digital asset. So the shelter principle in Principle 9 gives the transferee whatever rights the transferor would have had, and we'll come back in a moment how that works in terms of what rights the transferor may have. But the transferor, whatever it has, using our concept of transfer, that person can pass along those rights to the transferee, again, without getting quite yet into the innocent acquirer. And this rule does not depend in the principles on knowledge or notice or anything, or value, anything like that. It just says whatever I've got, I can give to Ed. So Ed, the UCC, how does it deal with shelter?
Exactly the same way. Whatever rights the transferor had go to the transferee. Now, let's say that I thought I had a controllable electronic record, but Steve hacked into my computer, and he was able to obtain control of this controllable electronic record and transfer it to Alejandro here. So Steve is a thief.
No.
He has no right, no right to my controllable electronic record. And when Steve transfers that controllable electronic record to Alejandro, Alejandro takes subject to my ownership rights, and I can claim that controllable electronic record. But it's whatever rights Steve had, Alejandro got.
So now we go on to the next question of, we talked about control already, and we have the innocent acquirer rule, which again is a core concept of the principles. And the innocent acquirer rule is going to tell us that the innocent acquirer is going to take free of claims. But let's get to the definition first of how this rule works. And it's somebody who has control. There's our key use in this part of the word control, control of the digital asset. And again, keep in mind the digital asset is only the digital asset as defined in the principles, not other kinds of electronic assets. And then here's where the modesty of the principles came into play. Principles could have then gone on and established a set of additional components that said there has to be value, there has to be good faith, there has to be the absence of notice of other parties, persons, proprietary claims. But then in discussions at Unidroit, each state, as with a capital S, say, well, we have this requirement, and another state we have that requirement. So Unidroit said, well, let's step back and not try to establish for this part of it. We understand everybody has similar rules, but they're not identical enough. And the goal of taking free of other persons' proprietary rights and certainty in the market is served sufficiently. If what we say is you have to have control, that's a principles point, but then you look to bona fide purchaser, innocent acquirer, however it's phrased in a particular state, and you add those on, and that would create the definition of the innocent acquirer for this purpose. So again, the principles are not answering every question, and in some cases there was a specific rule, in other places a more general rule. So Ed, how does and we just mentioned the common law of the United States has very little on this. One of the restatements on restitution and equitable rights says that an innocent acquirer cuts off equitable rights but not legal rights, and in the United States legal rights are more property and contract rights, equitable rights are fashioned out of equity. So it's a very narrow kind of rule. But I think the UCC really stood up here, Ed.
Well, the changes to the Uniform Commercial Code do provide the attributes for what an innocent acquirer would have. The term that is used is a qualifying purchaser, and a purchaser is any voluntary transferee. So we start off with a purchaser that acquires control of the controllable electronic record for value, so that takes away gifts. I was amused yesterday that the English translation of value was something that was onerous. Yeah. But we wanted to make sure that value really meant in return for existing consideration, monetary or other consideration. And then the person also has to act in good faith, which we defined as honesty in fact and the observance of reasonable commercial standards of fair dealing. And then finally, that the person who acquires control in order to be a qualifying purchaser must obtain control without notice of an adverse claim to the controllable electronic record. Now, we wanted to make sure that notice did not require the acquirer to do a search in a registry. So we say specifically that there's no requirement for the acquirer to do that, but otherwise, if the acquirer is on notice of the adverse claim, it can't be a qualifying purchaser. So I think we get to the same place as the principles, applying our own substantive law for what the attributes are of an innocent acquirer.
So if one manages to be an innocent acquirer, what does one get? And under the principles, one obtains whatever proprietary rights were transferred to that person. And again, the proprietary right could be ownership, full ownership, could be a security right, whatever those rights are, to whatever extent those are free of or not subject to the proprietary rights of other persons. And keep in mind that in order to achieve this status, one has to have control plus the elements of good faith, value, lack of notice, however they're expressed in a particular state for these purposes. So this is a very important right, and coming back, tying this together with the shelter principle, if an innocent acquirer acquires a digital asset free of other proprietary rights, and then they transfer it to a third person, there was another transfer that goes on, and the third person knows about the prior proprietary claims. Because of the shelter principle, the person in the middle, the first acquirer, as an innocent acquirer, they acquired the digital asset free of other proprietary claims. So they can pass that status along to the second buyer or acquiree, however you think about it. Even if that person's standing alone, would not be an innocent acquirer. So this, again, in terms of how the markets work, if someone says, well, I'm going to buy a digital asset, and I don't know of any claims to it, then I'm in good shape. And I don't have to worry about any of these potential litigation points. Again, the common law in the United States has very little on this. Ed?
Really the same result under the Uniform Commercial Code changes, that if you are a qualifying purchaser, you obtain control and you cut off adverse property claims to the controllable electronic record. Now, think about what this means in the context of just buying Bitcoin. Before the 2022 amendments to the Uniform Commercial Code, there was no rule that cut off adverse property claims to the Bitcoin. If the Bitcoin was stolen and went to Steve, and Steve sold it to Alejandro, and Alejandro sold it to David, I could come after David, even though everyone in the chain was innocent. But that was not how people dealt with Bitcoin in the marketplace. They dealt with Bitcoin as if it were money, and at least a medium of exchange. So what the qualifying purchaser rule does and the innocent acquirer rule does is really codify what the market expects for the transfer of these assets.
So we're going to move now from innocent acquirers, shelter rules, control, to various matters involving custody of a digital asset. And has been mentioned several times, it's widely expected that a lot of people, one way or the other, will have or hold, I shouldn't use the word hold, will have their digital assets in custody somehow with somebody else. A large business may know how to do all of this, but an individual buying and selling crypto probably has no idea how to get it. So they enter into a contract with an exchange or a service provider or something like that to manage the transactions in the digital assets, principally crypto, maybe for individuals, but businesses will have all of these other kinds of assets that can be digital assets. So there are elaborate provisions in the principles on custody. We've heard already and talked about the definition of custody, and we have a client and a custodian, and the custodian holds the assets in a way where the expectations are that the assets remain, the proprietary rights in the assets are those of the client. There may be a custodian in turn may use a sub-custodian or another custodian to hold the assets for the first custodian, and there are further elaborate rules in the principles on how one has control of something where there are 2 or 3 or 4 or 5 custodians in line, each maintaining, and maintaining in English is the key word here, a digital asset for its client, and then its client is a custodian for another client, and so forth. And if all those rights are maintained all the way up the chain, then we've got a series of custodians, and we'll talk in just a second about how the various rights of control flow up that chain. In the United States, nothing really comparable. We have an extensive law of bailments, but the law of bailments is limited to goods or tangible objects, and it sort of kind of fits these intangible objects. And if you look at contracts that people use in the United States today for custody, they use the word custody of digital assets. Somebody took a form off the computer and just changed the word goods to digital assets and used the same basic form. We have a restatement of property underway that has extensive provisions on bailments. I've been talking to the reporters about drafting some comparable, not identical, but comparable provisions to deal with custody of digital assets similar to bailments without disrupting the law of bailments. So that's our sort of common law approach. The principles, again, recognizing this, have pretty extensive stuff. UCC up to speed on this, Ed?
Well, there are different ways that parties could structure a custodial arrangement if they would like. Under these 2022 amendments to the Uniform Commercial Code, if I have control of a controllable electronic record, I could acknowledge to Steve that I have control for Steve. And that largely makes me someone like an agent for Steve, where Steve controls through me. And it also makes me someone like a custodian at that point, because I'm holding that controllable electronic record for Steve. So I can do that under the 2022 amendments to the Uniform Commercial Code and act as Steve's custodian in that sense. Now, the one thing I can't do is say, I have this controllable electronic record, I'm going to transfer it to Steve, Steve is going to acknowledge that he holds it for me. That is not recognized because I haven't really transferred the benefits and burdens of ownership to Steve. I've really retained all of those for myself. But other than that, I can say I'm holding the controllable electronic record for Steve. There is another way to do this under US law, and that is under our Article 8 of the Uniform Commercial Code. Now, Article 8 of the Uniform Commercial Code deals with the transfer of investment securities. But we also have in that Article 8 provisions relating to what we call the indirect holding system, where I may believe that I own securities, but my securities are really with my broker, and my broker holds those securities through a clearing corporation, and that what I have is what we call a security entitlement, a contractual right against the broker, and a property interest in the securities that the broker holds for me. Now, we refer to my account with the broker as a securities account, and I have this security entitlement against the broker. But the definition in Article 8 of what constitutes a financial asset that a broker can hold for me is broader than just securities. The broker can hold for me any other asset that the broker and I agree to treat as a financial asset. So if I go to a broker and say, I want you to hold my cryptocurrency, and the broker agrees, and the broker says, I'm going to treat the cryptocurrency as a financial asset under Article 8, then the broker, all the Article 8 provisions come in, the broker is my custodian for the digital asset. And in the 2022 amendments, we made it clear that a controllable electronic record can be a financial asset subject to Article 8. We also made it clear that the broker, which we call a securities intermediary, doesn't even need to deal in securities. It can deal just in controllable electronic records. So if you think about these large cryptocurrency exchanges that you've read about, Coinbase, FTX, or whatever, they could have qualified as a securities intermediary holding a financial asset consisting of a controllable electronic record. So there are two ways to do that. The first way is very skeletal. It just refers to the fact that I am holding the controllable electronic record for Steve. The second way, where we bring in all of Article 8, there is a whole statutory framework that we will talk about.
So one more small point on custodians, and then we'll move on to secure transactions and insolvency and wind up in the next 8 minutes or so. What happens if the custodian is holding the digital asset for the client and the custodian goes into bankruptcy? Does the client's interest in the digital asset held by the custodian protect the client from the claims of the creditors of the custodian, or do those creditors get that and the client finds that it's just another creditor of the custodian? The principles, and maybe a little bit of a circular fashion, because the definition of custody says the anticipation is that the digital asset is not subject to the claims of the creditors of the custodian, and the principles go on to confirm that result, that if we have a true custody relationship, then the creditors of the custodian would not have those rights. Ed, anything in the UCC on that?
Well, yes. If I am holding a controllable electronic record for Steve, and I am like a custodian at that point, if I go into an insolvency proceeding, hopefully the insolvency tribunal will say, that's not my asset, that's Steve's asset. This is even clearer, though, if the Article 8 approach is used, because then, as a matter of statute, the assets are not part of the insolvency estate of the custodian. They are only assets of the customer.
All right, we're going to move on to secure transactions at this point and give a little bit of that. In the principles, we start off with some basic notions that, because way back at the beginning, we say there can be a proprietary right, large or small, in a digital asset, and it's expressly stated in the principles that includes a security right in a digital asset. So under the principles, there's just no problem in terms of creating. We'll come to effectiveness against third parties and priority in just a moment, but there's no problem in creating. And then when it comes to linked assets, which we've already talked about, the question of whether a security right in a principal asset, we call, extends to any asset that is supposed to be linked to the principal asset. And the principles say, go look to other law. We're not going to tell you the answer to that question, just as we don't tell you any of the answers to the questions about linked assets. If other law says the link works for all these purposes, great. If it says it doesn't, too bad. And U.S. common law throws up its hands. Ed?
Well, when you're dealing with controllable, what we call controllable accounts and controllable payment intangibles, these are these embedded payment rights in the controllable electronic record. Those transfer with the controllable electronic record. So if Steve obtains control from me of a controllable electronic record that evidences one of these payment rights, he gets the payment rights as well. Now, the key is that the person who is obligated on that payment right has to agree to pay the person in control of the controllable electronic record. If you don't have that agreement by that obligated person, then the right to payment does not travel. But as long as you have that agreement, I think that you are okay. Now, we already have rules in our Article 9 of the Uniform Commercial Code dealing with creation of security rights. And those rules apply to a controllable electronic record or one of these embedded payment rights, just like they normally would.
And there was a concern raised yesterday about there's no specific definition of what a security right is or a secure transaction system is. And in the principles in comment 14.3, it says this is intended to defer to whatever a state itself characterizes as a security right, and it can be very broad. Some states apply their security rights law to outright transfers of payment rights, for example, and if that's so, that's fine. The rules in the principles will apply. There's precious little common law in the United States in this area because the UCC has been around for 60, 65 years, depending on the unit of the United States. So the common law has sort of gone away until 1999. UCC didn't cover deposit accounts, so there's a little bit of common law there, but we tend to ignore it.
And if you look to then our Uniform Commercial Code and Article 9, we have perfection and priority rules. Now, I know a lot of countries combine the two and they just refer to priority, but we have this idea that perfection means that you can prevail over a creditor who obtains a judgment lien on the asset, and priority deals with competing secured parties, buyers, lessees, things of that sort. So you can perfect a security right by control of a controllable electronic record, and a perfection by control has priority over perfection by some other method. So I don't need to worry about whether, if I'm obtaining control of a controllable electronic record by way of a security right, I don't need to look at the registry to determine whether someone is claiming a security right in the same asset. If I have control, as long as I don't have notice, if I have control, I prevail, whether or not I have notice. If I want to be a qualifying purchaser, I can't have notice, but all I need to do is to get control in order to have priority.
Yeah. And that priority is only against another secured creditor, but not against others who claim proprietary rights in the digital asset. Let me just two more items here under secured transactions. One is the ability to make it, under the principles, to make the security right effective against third parties by control or registration if the state has a system of registration of security rights, and the advantage for making it effective against third parties by control is, as was noted in one of the comments yesterday, that effectiveness by control has priority in a declarative sense. The concern was as against another secured creditor who has made its security right effective by a method other than control. And there was some concern expressed yesterday, well, that's a declarative flat statement. That doesn't seem right. And I think the answer to that is that the principles, again being modest, did not attempt to define all of secure transactions law. There are numerous references to the model law on secure transactions from UNCITRAL. The UNCITRAL model law and the legislative guide both say it's fine if two secured creditors who have senior and junior priority agree between themselves that the junior will become senior and the senior will become junior. So I think the provision in the principles that says a secured creditor that has control has priority over another secured creditor that does not have control is a rule, but those two parties are free between themselves to enter into an agreement. So I would hope that would not be a concern in these areas. And again, in the common law, not really addressed.
And same under the UCC, that one can always subordinate by contract.
Yeah. So finally, on insolvency, we've already discussed that the rights of somebody under the principles should survive the insolvency of the transferor or the person who created the security right or something like that. And there was concern expressed yesterday that there was no clear definition of insolvency. There's a general definition up front. Nacho talked about it today, and the intent is clear from the comments that it's intended to be very broad. If there's a common system, judicial, administrative, that addresses the rights generally of creditors of a person. So I think that definition and approach should work fine.
And under our insolvency law in the U.S., if a security interest has been perfected by registration or by control, security interest in the controllable electronic record, that would be recognized in the insolvency proceeding, subject to the same sort of special rules that you find mentioned in the principles, like fraudulent transfers, preferences, things of that sort.
So overall, the goal of the principles has been to have clear, precise rules, not to try to answer every question, but where it does provide an answer, to give direction, to recognize market transactions and provide sort of a legal infrastructure around what market participants think they're doing, somewhat times erroneously, in terms of the legal effect today, to provide as much predictability as practical as we go through all this. And Ed, UCC's goals?
Very much the same, but also to provide uniformity and among states, and hopefully with discussions like this among nations.
Yeah, and as you've heard, there's great level of uniformity between the principles and the UCC. So I assume this will be available, David, our chart?
It could be.
Yeah, we're happy to make it available if you think it's useful.
It's very useful. I think that the structure is
Yeah.
very clear and so clarifies very well, which is the inputs and
Yeah.
how it is solved.
Yeah.
So I'm very. Well, I was trying only to answer the question if this is open. Thinking if you send us, we can provide to everybody. And anyhow, as you know, the idea is to end up in a book in English and in Spanish. So this could be. The only question is how you would like to present that in the book. It depends on how, on you yourself. No, but anyhow, this could be distributed without any problem. But now that I have the microphone, I need to give thanks. I think it's a need because we were coming here, Ed and I said, I do not know if the idea that we provide was just, and I said to him, you know, we have been so much time working together that I'm absolutely sure that and I must tell you that I'm so surprised how you connect both. I mean, the principles and the solutions. That I must congratulate you both. No, you know, it's just, you know, and I think that I convey the ideas of all of us. You know, it's well, we all usually go to a conference and so on, but this way of doing things is so fresh, so attractive that congratulations again. So I think that we have to stop anyhow. No? Creo que tenemos que parar, me parece.
I think we need to stop now.
Stop, but congratulations. Thanks.
Well, and thank you all.